So we're on YouTube. Are you ready, Leslie?
Yeah, I'm ready.
All right. So calling Martha Esch versus Locke Management Association et al. It's actually three motions on calendar this morning. Locke Foundation's motions for sanctions, Sacramento County Board of Supervisors motions for sanctions, and then the Sacramento County Board of Supervisors demur. It's case number 34-2020-8000-3482. Ms. Esch is appearing via Zoom representing herself. And counsel for petitioners, you want to state your appearance for the record?
Martha Esch in proper here. Thank you,
Okay.
Your Honor.
Thank you. Go ahead, Ms. Hollins.
Susan Holland for defendants, Sac County Board of Supervisors, and the Locke Foundation.
And Ms.
Sorry,
Esch.
I'm having a hard time hearing you. I didn't hear the last part.
I'm sorry, my speaker is not functioning. I tried.
It's muffled, yeah.
Connect my ear. Just 1 second.
Yeah, you're really muffled from my end too.
Is that any better?
No.
No, not really. You want to log off? Sometimes it's just logging off and logging back on. You want to log off and get back in, and I'll let you in the waiting room? Okay. All right, try it again, Ms. Allen.
Can you hear me?
A little better.
A little better?
Yeah, no, that's better, I think. We're getting a little bit of an echo. Does somebody have YouTube open? Okay. All right, anyway, so let's start first with the...
Well, I didn't get all the appearances. Sorry, Judge.
Oh, go ahead. Sorry.
I only got, she was with the county board and I didn't get the last part.
Locke, defendants, Locke Foundation.
Okay. And then?
Yeah, and good morning, Your Honor. Carl Fessenden, also on behalf of the County Board of Supervisors and the Locke Foundation, although Ms. Holland will be handling the hearing.
Great, thanks. All right, so let's start first with the sanctions motions. Respondent had asked for oral argument. Obviously, I read the pleadings, I understand the arguments, but Ms. Holland, whenever you're ready.
So speaking first to the Locke Foundation sanction motion, we recognize that the court didn't get the declaration from Stuart Law Hall. We understand that that has important evidentiary implications for our request. We're not sure what happened. We know that we did send it to Ms. Esch on November 18th via both electronic service and by mailing. What we request at this time is that Your Honor would continue the hearing on that sanctions motion so that we can properly submit the document to the court.
I guess my question is, I'm not entirely sure that even if I had it, it seems to be now I have a sanctions motion where petitioner says the board's intertwined with the foundation. And defendants say in their 128.7, no, here's a declaration that says they're not. And I'm kind of wondering, isn't that really, now we're just to the merits of the thing, and shouldn't I be doing that in a merits hearing instead of a 128.7?
So our position, Your Honor, is that because, within the meaning of the Brown Act, the Locke Foundation isn't implicated in tandem with the other entities and is separate and distinct from them and isn't subject to the Brown Act and can't be. And that's our position, Your Honor.
Okay. Anything else you want to say on the, I'll think about it whether or not we're going to continue or not, but let's just, anything else you want to say on the Locke Foundation motion?
No, Your Honor.
Okay. And then did you want to be heard on the Board of Supervisors 128.7?
Yes, Your Honor. Just briefly, we ask that you reconsider. We understand that you're concerned that we didn't adequately dispel all the various ways in which Ms. Esch's claims cannot be brought. And, we partially did that to, to succinctly submit to the court our arguments. And essentially, we just want to reiterate to the court that the acts that Ms. Esch is alleging against the board aren't viable, and we just ask that you reconsider, basically.
And Ms. Esch, before we move to the demur, did you want to be heard at all on the sanctions motions?
Yes, sir. Oh boy, I'm hearing an echo too. Regarding the 128.7, I think it is, or that they are saying, the public has a right to ask questions at board meetings concerning the policies and the...
Okay, Ms. Esch, I don't mean to cut you off, but and you tend to do this in your pleadings. I don't want to argue the merits now.
Okay.
I don't want to get to that. You need to focus in on the 120.7, their arguments they're making. I've ruled in your favor, so you don't really need to argue unless there's something you want to add.
Okay.
But this is not the time where we're going to get into the public's right and the Brown Act.
Okay.
That's all for the merits. We're going to get there. And I know you want to get there, and I appreciate that, but I'm not ruling on that today.
Okay, Your Honor.
Okay. So then let's turn to the demur. The demur was sustained with leave to amend. I guess I'll start first with the petitioner, since you were the one who requested oral argument. Were you wanting to, I'm sorry, the respondent, were you wanting to argue on the demur as well, or are you submitting on that?
Briefly, Your Honor, we do want to ask the court reconsider granting the leave to amend. Our position is that it's futile, that she didn't allege sufficient, fact or legal argument in her writ that connects the board with the LMA. That it's not possible. Nothing that we found in the law would allow for the board to be vicariously, or even in contract theory under a principle. There was no agreement that the board, that the LMA, a separate, distinct, common interest development, could, act on behalf of the board, and it's not properly pled, and it can't be. So we just ask that you reconsider the grant of leave to amend.
Right, but I mean, you may want to think about the bigger, longer picture. I mean, if I sustain a demur without leave to amend for a pro per, my guess is it's going to get reversed down the line. So, do we really want to do that at this point, or do we want to just, I'm not really in the merits, or do we want to give her one more chance to amend if she wants to amend? I'm not sure there's anything there, but I'll give her another chance to put it there, and then we just wrap it all up in the merits instead of piecemeal having this thing bounce back and forth between the Court of Appeal. So that's kind of where I come out on that one. Ms. Esch, do you want to be heard on the demur?
Yes, sir. Yes, sir. And on what you just said there, and I really appreciate your tentative allowing me to amend my petition. I wanted to ask if you should grant leave to amend, may I resubmit the exhibits that were stricken from the record because I was late with the filing? That's one. I've got 3 or 4 questions here. May I resubmit those because they're important? They're foundational exhibits.
Well, again, ma'am, I can't give legal advice, but I can tell you this: if I give you leave to amend, that is leave to amend your complaint. So if exhibits were stricken because they were late filed, that doesn't necessarily mean you can't put them in an amended complaint. If they were stricken for some other reason, then they'll probably be stricken again.
Okay. Let's see. May I also include in the amended filing recent Brown Act violations that have been ongoing with the 3 respondents since I made the initial petition back in September?
Yeah, that's more of a legal question. I really can't give you advice on. I mean, whether or not what you want to include in the scope of your complaint, I can't tell you kind of how to frame that.
Okay. And another question. I am asking you, Your Honor, to issue a directive or an order to have the petition or the respondents, excuse me, the 3 respondents preserve their ongoing meetings that are going on now by video that are publicly accessible through an online link. And may I include those links?
Well, ma'am, let me say this about that. This is the first time I'm hearing about that. So if that's something you want me to do, you need to file a notice motion, and I need to give the other side a chance to respond and tell me why I should or should not do that. So I just can't, as I sit here today, say, okay, I'm ordering you to do X, Y, and Z. They get a chance to weigh in on that and tell me why I shouldn't do that. So if that's something you want, then file a separately notice motion and give the other side a chance to respond, and then once everybody gets a chance, we'll litigate it.
Thank you, Your Honor.
Anything else?
I don't think so. Thank you.
Okay. Anything else for petitioners? I'm sorry, respondents?
No, Your Honor.
All right. Well, I appreciate the arguments. At this time, I will affirm the tentatives, and then I guess going forward, we'll set a merits hearing, or Ms. Esch will file her amended complaint, and we'll take it from there. All right. So with that, the court will be in recess.